Good evening, everybody, and welcome to another edition of Words and Worlds, New Directions in the Philosophy of Language. It's a great pleasure to welcome our speaker for this evening, Professor Emma Borg. Emma's Professor of Philosophy at Reading, where she's also Director of the Centre for Cognition Research. With a wide range of philosophical interests, including philosophy of language, the philosophy of mind, and also business ethics, she's the author of 2 books, Minimal Semantics and Pursuing Meaning, and numerous articles and edited collections. Great to have you with us tonight. Emma's talk will be entitled, What is it to be responsible for what you say?
Lovely, thank you, Edward, very kind. Thank you for that kind introduction, and thank you to everybody for coming out on a relatively chilly Friday night at 10 to 7. I mean, that seems like a level of dedication to the intellectual pursuit that I'm very impressed by, so well done, everyone. Okay, so my talk tonight is going to be, what is it to be responsible for what you say? And just a word to start with, I'm responsible for most of what I'm going to say, but some of it, the bit we're going to get to when we start talking about hate speech, is the result of a joint project that I've been involved in called the Law and Corpus Linguistics project that we've been running at Reading. That's a joint project between a linguist, Sarah Villa-Lurch, someone in politics, Maxime Laputra, and another philosopher, Nat Hansen. Nat Hansen is actually here in the front row, so any really wrong bits I'm going to direct her towards him, any difficult questions. Okay, so just by way of introduction then, I'm interested in the idea that people have a practice of taking other people to be responsible for what they say. And that seems to be a crucial feature of our linguistic use, okay? If we didn't have this ability to hold one another responsible for what they say, we couldn't use language in the way that we do. You know, it's because when you tell me there are cookies in the jar, I can take you to be responsible for the truth of that utterance, that I can use what you say to direct my cookie hunting behavior. You know, if I couldn't hold you responsible, we couldn't use testimony in the way that we do. But when we start thinking about it, I think that practice of holding each other responsible looks a bit more complicated than we might initially have imagined. So we need to know what it is, what's going on when we hold people responsible for what they say. And what I'm going to suggest in this talk is that to answer that question, or to begin to answer that question, we need to answer 2 prior kinds of questions. First of all, we need to know what someone said. You know, we can't hold people responsible for the content of what they say unless we know what they said. We know the content that they expressed. So in the first part of the talk, I'm going to try and think a bit harder about how we settle on the content that people express. And then secondly, I'm going to suggest that we need to know something about the sense of responsibility in play. You know, what is involved? What are we saying when we hold someone responsible in this way? Or what's this notion that I'm going to call kind of linguistic liability? What sorts of liabilities, what sorts of responsibilities do you assume when you say something? So I'm going to try and explore those 2 questions. And to give you a bit of a sense of the plan, most of the talk, or at least the first kind of 2/3 of the talk maybe, is going to be focusing on this question of how we get at the content. How do we work out what it is that someone said? I'm going to suggest that to answer that question, we need to think a little bit about the way that the content, the linguistic content of what you say relates to the context in which you say it, the utterance context. And I'm going to suggest that there are 3 different kinds of content we might get hold of when we think about that kind of relationship. I'm going to be particularly interested in one of those kinds of contents, which I'm going to call minimal content, because that's the view that I've defended in lots of places. So I'm going to tell you a little bit about that, but we won't get too kind of hung up with all the details. But what we're going to see is that minimal content requires us to know about the meaning of a word, and we might think that that's a pretty difficult question to answer as well. Actually, on reflection, how do we know what words mean? I'm going to suggest various different methods, both subjective and objective, and to try and give some flesh to this idea of an objective way of finding out about the meaning of an expression, I'm going to look at a case study involving the expression hate speech. Okay, so I'm going to look at some objective ways of understanding what we might be meaning when we call something hate speech. That's going to conclude what I'm going to say about how we settle the meaning of what someone has said. But we're then going to face the problem, right? Because I told you there were 3 kinds of content at the beginning. I've only told you about one of them, and we might start thinking that we've gone down totally the wrong track because this kind of content, the one I'm going to tell you about, may not look terribly interesting. It may look like it's the wrong sort of content when we're interested in questions about meaning. But that's when we're going to turn to the second question, to do with a sense of responsibility. And I'm going to suggest that when we think about responsibility, we can see that actually our judgments of responsibility at least sometimes track this notion of content that I've given you. So I'm going to identify 2 different kinds of liability, what I'm going to call strict versus conversational. And I'm going to suggest to you that strict liability requires the notion of content that we've been interested in. So that's why it's worth thinking about it. And then I'll conclude. Okay, so let's see if we can get that done in the next kind of 45 minutes. Okay, so here is a toy kind of case. Let's imagine that Abe is talking to Bishma and he says, "Do you want a sandwich?" To which Bishma responds, "Oh, I've eaten." And we might wonder to ourselves, well, what content is Bishma responsible for here? What's he actually expressed by his utterance? And it looks like there are at least 3 possible answers here, right? For those of you who are in the know, I know we've got some philosophers of language in the audience, this will be very familiar to you. We can get different kinds of answers depending on how much we let the context of utterance play into the content. Okay, so one kind of content we might get hold of is this minimal kind of content, where we really don't let the context have much of an effect at all. Okay. So what we look to really are just the words that Bishma's uttered and what they mean and the way that they're put together. So we might think we've got to look at context a little bit because we've got to find out who the referent of I is. But beyond that, beyond cases where there's a kind of immediate call for looking at the context from the words themselves, minimal content says just stop there, just look at the words. So what we get for Bishma's utterance here is just the content "I've eaten" or just the content that Bishma's eaten, full stop. But alternatively, we might think we should let a bit of the context in order to get a kind of richer content here. And for those of you who know, this is the kind of content that's been particularly of interest to advocates of what's called relevance theory or certain kinds of contextualism, and it's sometimes referred to as an explicature content, because it's the content that the speaker kind of makes explicit in their utterance. But here you let in a little bit of kind of extra content. You can't seem to find this bit of content in the words themselves, but something about the context seems to let them in, make them figure. So when Bishma says, "I've eaten," it seems reasonable to think that what he expresses is something like, "I've eaten today," or "I've eaten lunch," or "I've eaten recently." Something a bit richer than the minimal content we begun with. Or thirdly, we could allow the context kind of completely free rein. We could think what we're really interested in is the message that Bishma's trying to get across, and that might be very different to just the strict words that he's uttered. So we might think that really what Bishma is expressing here is something like an answer to Abe's question. He's saying, "I don't want a sandwich." Now that's very different to what the kind of literal meaning of the sentence is. "I've eaten" doesn't literally mean "I don't want a sandwich," but nevertheless it looks as if that's a content that Bishma might be taken to express once we factor in the kind of contextual exchange that he's engaged in. Okay, so I want to focus on this first notion that I gave you, this notion of minimal content, and that's because I quite like it. It's a position that I've tried to defend in a number of places, particularly in a couple of books. Lost the colour of my nice covers here, but never mind. So minimal semantics at heart makes a really simple claim. It's a very flat-footed kind of theory. What it wants to tell you is just that if you want to get at the meaning, the kind of literal, what philosophers call the semantic content of our expressions, if you want to know the literal content of a sentence, you just need to know about the meaning of the words and the way that they're put together. Once you've got that content, you can just derive the content of any well-formed sentence, and it's going to give you a kind of a complete claim. It's going to give you a claim that if you held it up against the world, you could find out whether the claim is true or not. So minimal semantics holds that literal meaning, or what philosophers call semantic content, is fully determined by word meaning and structure. But that clearly pushes us to ask another question, right? If that's how we determine the meaning of a sentence, how do we know the meaning of the bits that we're interested in, right? How do we know the meaning of our words that we're going to plug into these sentential structures and get content out? And on reflection, that seems like a real question, okay? How do we know what a word means? Now, intuitively, that may seem a really easy question to answer, right? You may think that, you're a competent user of a language, you're a competent user of English or French or whichever language we're interested in, and as a competent user of a language, surely you can just reflect on what you think a word means, and that gives you the meaning of that expression. Words mean what you think they mean. But on reflection, that seems potentially problematic, right? It seems potentially problematic because maybe you're an idiosyncratic speaker. Maybe you've had an odd background, maybe, I don't know, what's a sandwich like in Iceland, Elmer? Are they terrible, okay. But maybe I've grown up thinking that an open sandwich is definitely the only kind of sandwich there is, and I wouldn't really classify something enclosed between two bits of bread as a sandwich. So maybe I've got an idiosyncratic past, and even if I haven't, maybe when I think about meaning, I don't really settle all the questions we might need to answer when we're worrying about meaning. So if I reflect on what I mean by red, I don't know, do I mean that something has to be red all over to count as red? Do I think it has to be red on just some part? Do I think it has to be mostly red and not mostly red? It's not obvious that reflecting on, introspecting about my thoughts about meaning are going to answer these kinds of questions. And furthermore, thinking that we need to answer these kinds of questions isn't just some kind of, abstract ivory tower kind of consideration. It's the kind of consideration that really matters in the external world. And to see that, I just want to spend a little while now considering two concrete cases where people have worried about the meaning of expressions. So one's going to be a consideration of the meaning of the word widow, and one's going to be a consideration of the meaning of wife or husband. So maybe to make this into a proper thought experiment, maybe just reflect for a minute what you would think the meaning of these expressions is or are, and we'll see whether it aligns with the judgments that people arrived at. So firstly, thinking about widow, a bit of legislation that we're interested in is up here at the top. It's Section 262 of the Income and Corporation Taxes Act 1988, and it claims that a widow shall be entitled in certain kinds of situations to an income tax reduction of a certain kind. I haven't bothered telling you what the situation is or what kind of tax reduction it is, because really we're just interested in this idea that the law stated that a widow in certain situations is entitled to a tax reduction. And the history of this case is that one Mr. Crossland, who was a widower, brought a complaint under the European Commission of Human Rights, alleging that Section 262 was a breach of Article 14, which disallows discrimination on the basis of sex. Okay, so he was a widower, not a widow, but he argued that he should be allowed to claim that benefit because otherwise it was discrimination on the basis of sex. The HMRC commissioners considered his case, and it never went to court because they settled out of court with him. They agreed that there was a breach, or at least there was no agreement, but they paid him the £572, which was the required tax relief. All well and good. Subsequently, in 2000, Mr. Wilkinson, who was also a widower, simply claimed the tax relief on his tax returns. He stated that he was entitled to this and he claimed it. At that point, the HMRC commissioners rejected his claim. They said no, he couldn't have that tax relief because he wasn't a widower. He wasn't a widow, he was a widower. They agreed that that breached the European Convention of Human Rights, but they stated that they were warranted in imposing this because it wasn't up to HMRC to change the law. If the government wanted the tax law to be in agreement with the European Convention of Human Rights, they needed to change the law. But all the HMRC commissioners could do was apply the law as it was stated, and as it was stated, it applied to widows and not widowers. So Mr. Wilkinson took his case to the High Court. And he appealed the decision on a number of bases, but the one that's of interest to us is this one down at the bottom here, where his lawyers argued that Section 262 should be read as meaning widows or widowers, as having a meaning that incorporated any surviving spouse. And they argued that it should have this meaning because of Section 6 of the Interpretation Act 1978, which states that unless the contrary intention appears, words importing the feminine gender are taken to include the masculine. So that appeal was turned down, and in his comments, Lord Hoffman, who supported that judgment, pointed to a couple of facts. He said, look, the draftsman who drew up Section 262 and the rest of the legislation didn't have any difficulty in finding a gender-neutral term when they wanted one, so in other sections they had gender-neutral language, and furthermore, when they intended a benefit to apply to both, they explicitly stated that it was to apply to widows and widowers. And the fact that that didn't happen in 262 meant that they didn't have that intention. And he concluded there is no way in which any reasonable reader could understand the word widow to refer to the more general concept of surviving spouse. Okay? So an interpretation of widow which says it has to have this narrow meaning where it depends on the sex of the individual. Now compare that to another case which dealt with the phrase wife or husband. So the facts of the matter in this case is that a landlord, Gaydon, sought repossession of a flat on the death of the tenancy holder of that flat, one Walwyn James. Now at the time the flat was occupied by Walwyn James's long-term homosexual partner, Godwin Mendoza, and this was pre-changes to the Marriage Act. Now if the flat had been occupied by the wife of Walwyn James, they couldn't have been evicted. The tenancy would have to have passed to them. But that wasn't the case here, because it was allowed, Gaydon were allowed to claim repossession of the flat, and Godwin Mendoza objected to this. He appealed his eviction in 2004, arguing that any ruling, as the lower courts had made, that a homosexual relationship was not covered by the UK Tenancy Act, again was in breach of the European Convention. And in this case, the appeal was upheld, okay? It was stated that he should have been allowed to maintain the tenancy of the flat because in this piece of legislation in UK tenancy law, it was stated the phrase as his or her wife or husband should be held to mean a relationship of social and sexual intimacy exemplified by, but not limited to, the heterosexual relationship of husband and wife. So in this case, we have an interpretation of an expression which goes wider than we might initially have imagined. It includes anybody who plays this typical role, not limited by sex or gender. So it seems like we have two different kinds of findings, right? In the case of widow, it was found that it couldn't be understood in the wider sense of surviving spouse. In the case of wife or husband, it was found that the meaning should be understood in the wider sense. And I think what these concrete cases show us is that we really ought to think a bit harder about how we decide the meaning of expressions. You know, it comes up very clearly in these contested cases, but I think they help to demonstrate that just, ordinarily, maybe reflection, maybe introspection, isn't always going to be the right guide to questions of meaning. So that pushes us on this question of how we're going to decide the ordinary meaning of an expression. How do we know what someone has expressed when they say something? And it seems to me that we've got a range of possible methods here, right? We've got absolutely subjective kinds of approaches, where we just look at what the speaker intended, or we look at what the hearer recovered. Just ask competent language users to reflect on what they're doing, and they'll deliver you a judgment on meaning. But I think alongside these kinds of subjective approaches, we also have a range of more objective kinds of approaches. And these are very well known, right? Because a classic kind of objective approach is to go and look in a dictionary. Maybe that was what struck you when we were talking about these contested cases. Maybe the thought is they should have looked in a dictionary. And in fact, in legal practice, that's what you find a lot of, right? They appeal to a dictionary, and you'll often find two opposing legal advocates appealing to different dictionaries because they get different definitions. So it doesn't always settle things, but they will often go and look in a dictionary. And that's objective because you're going to an external source, right? You're not saying just reflect on your own intuitions, you know, go and consult an expert, the thought is. But recently, additional kinds of objective measures have come up. And actually, you know, I say recently, but I'm sure Nat would correct me here, because one way of understanding a long-standing kind of philosophical tradition, this idea of ordinary language philosophy that was done in Oxford by J.L. Austin around the time of the war, one thing you could understand them as doing is running kinds of experiments where we ask people or we reflect on the way in which expressions might get used by the ordinary population. So we might go out with, you know, kind of questionnaires and stop people in the street and ask them, what do you think the meaning of this expression is? Or do you think this expression would apply properly in this kind of situation versus that kind of situation? So we try and find out a bit more about kind of how ordinary members of the public are using given terms. And finally, a final kind of objective approach, and one that I'm going to try and flesh out in a minute, we might appeal to some kind of corpus analysis. We might look at a big database and ask ourselves what that tells us about meaning. Now, all of these approaches face problems. Okay, so if I was giving a different kind of talk, I might have spent a bit longer telling you about what's good and what's bad about these different kinds of approaches. But just as a kind of, you know, to skate over the surface here, we've already noted that subjective approaches might seem problematic because, you know, maybe we have idiosyncratic answers coming from people who have peculiar linguistic backgrounds or very unique linguistic backgrounds. And there's also what philosophers like to call the challenge of Humpty Dumptyism. Okay, so for those of you who know your Alice in Wonderland, you'll know that in Alice in Wonderland, Humpty Dumpty is supposed to say that words mean whatever he wants them to mean. And that seems like a problem, right? Because for communication to take place successfully, we don't want people just meaning whatever they want words to mean. Words need to have a degree of publicity, a degree of stability. And if we just think that reflection, you know, kind of introspection is going to settle all questions of meaning, we might worry that we run into this kind of challenge. Alternatively, objective methods also look problematic, right? So they can be very cumbersome, they can be expensive to run, they can be difficult to do, right? Doing a really good experiment is difficult. There's been a big explosion in kind of academic philosophy in what's known as XFI. Sounds very, you know, cool. XFI is experimenting on people's intuitions to try and get a more objective understanding of them, but it turns out to be really hard, right? It's really hard to run a really good experiment that doesn't introduce kind of conflating features that make it difficult to read the results. And from a more kind of theoretical perspective, we might worry that usage isn't necessarily a good guide to meaning. So what these experiments are doing is looking at the way expressions get used, and we might think that maybe meaning doesn't just reduce to questions about meaning. So take a word like refute. You know, I'm not really sure what refute means anymore, but it certainly used to mean, you know, a pretty strong claim about being able to show by argument that a position was wrong, to provide evidence that would refute a given position. But certainly if we listen to politicians now, refute is just synonymous with reject, right? They just mean, I just don't like that claim. So we might think that looking at how people use expressions may not always be a good guide to meaning. So I think what we're going to have to end up claiming is that no one of these methods provides a kind of foolproof way of getting at the meaning of an expression. And this is a point that Lee and Moritzen have made in a paper dealing with kind of legal philosophy of language, where they suggest that what we're going to need to do is a kind of triangulation. We're going to have to, in contested cases at least, we're going to have to do some objective work, some introspective work, and we're going to have to put it all together in some way to arrive at our best judgment about what an expression means or the conditions in which it applies. But to try and substantiate that, I'm going to try and look at a particular case. Okay, so this is a case we've been working on recently, which is an example of an objective study of a given expression. So I'm going to try and show you what that might look like and show you why it might be a useful thing to engage in, the kinds of findings you might be able to get out of it. And the case we were interested in was the expression hate speech. Okay, so you've got to notice where the bunny ears are going here. We weren't looking at any particular instance of hate speech. What we wanted to know is what the meaning of that expression itself is. What's the meaning of the term hate speech, so that we know when it applies and when it doesn't apply, why we're calling a given instance of speech a given instance of hate speech or not. So to give you a little bit of the history, the term hate speech originated with legal theorists in the 1980s, primarily in the context of discussions of the racial issues in South Africa. So they needed a way to categorize these really harmful racist utterances in the South African political sphere. But it's become much wider, okay? Lots of jurisdictions now have hate speech legislation. And not all of it contains the term hate speech. Some of it does contain the term hate speech, but not all of it does. One example of that is actually in the UK. We have the UK Public Order Act of 1986, which I've put on the handout on the overhead for you. It doesn't mention the expression hate speech directly, but it's widely acknowledged as a piece of hate speech legislation. So the Public Order Act says a person who uses threatening, abusive or insulting words or behaviour, or displays any written material which is threatening, abusive or insulting, is guilty of an offence if he intends thereby to stir up racial hatred, or having regard to all the circumstances, racial hatred is likely to be stirred up thereby. Okay, if you do that kind of thing, you are liable for prosecution under the Public Order Act, liable for prosecution for promulgating hate speech. But as has been noted by a number of theorists recently, hate speech, although it began as this legal notion, doesn't seem to be just a legal notion anymore, right? It gets used widely by the ordinary public. And that raises an interesting question, right, which is the meaning of hate speech in public discourse the same or different to the meaning of hate speech within the legal domain? So that was the question we were interested in investigating in this objective study. And just before we get to that, we might wonder why it really matters. Okay, so is this really an interesting question? Do we really care whether the meaning is the same in these two contexts or not? But we suggest that it does matter, and it matters for a number of reasons, okay? Firstly, it matters for a question of interpretation. How do we work out what the content of a law is? So for many theories of legal interpretation, they suggest that the meaning of those legal terms is a function of the ordinary meaning of that expression. And that clearly shows you that we need to know what the ordinary meaning of the expression is, okay? We can't work out its legal content until we know about the ordinary meaning in the first place. Secondly, there's a key notion in any sort of democratic system, which is the notion of fair notice. You can't expect to impose a law on your citizens if those citizens are unable to know what's being required of them. Okay, fair notice demands that the laws that govern people are laws, the content of which can be found out easily by the population they're due to govern. But that requires that, as far as possible, words in legal context get used with their ordinary meanings. Okay? If the words in the legal context had some peculiar idiosyncratic content which was really only known by the lawyers, you couldn't use that to govern the ordinary population. So we require for fair notice that words have their ordinary meanings. And finally, particularly relevant for hate speech here, it seems that we want to avoid what's known as the chilling effect. Okay? So we don't want people to be self-censoring themselves, to be not producing expressions that they want to because they're worried about falling foul of hate speech legislation. So we don't want the self-censorship of legitimate speech. But if we're going to avoid that, if we're going to avoid this chilling effect, that again requires that the meaning of hate speech is the same across both contexts, the same across the public and the legal sphere. So we thought it was an interesting question to investigate whether these two things are the same, and we wanted to use corpus linguistics as a way of investigating it. So corpus linguistics then is the use of these large data sets of digitized texts to see what the meaning might be, and you analyze those texts using automated processing methods, software, comes in a range of varieties. We use something called Sketch Engine, but there are a bunch of tools available. And you take this big database of uses of expressions and you look for patterns. So the patterns that you might be looking for, typical kinds of analyses include kind of frequency analysis. You just see, look, within this big body of words, this big body of text, how many times does this word appear? What are the kind of main words that are getting used? You might do what's called a collocation analysis. So you look at the words that appear alongside your target word at a higher than chance level. So, if you're interested in the expression hate speech, you might ask your software to look at the 3 words that occur before it and the 3 words that occur after it, or the 5 words either side, or the 10 words. You can set your parameters how you like. And finally, you might do what's called a concordance analysis. So you might look at some randomly generated sample lines of text. So you do a kind of sampling across the whole corpus to see what that tells you. And corpus linguistics has emerged as an increasingly popular tool for settling questions of meaning, particularly within legal domains. And maybe in discussion, if people are interested, we could come back to whether or not this is a good idea. Because even though we think it's a good idea and it does tell you something, there are definitely problems with it, and there are definitely problems with the way it's been deployed. But nevertheless, we thought this could tell us something, or might be able to tell us something interesting about hate speech. So we ran a kind of pilot study. And to do that, we looked at 2 distinct corpora. The first one is a generally available corpora. So it's called the English Web 2020, also known as N1010. And it contains some 38 billion words. Okay, so it's pretty big. And it's one of the things that's nice about a corpus is that it's actual language uses. These aren't kind of lab-based constructed cases. They're just the way that people use words in the ordinary world. So 38 billion words drawn from English language internet domains between the period of 2019 and 2021. Mostly it contains blogs, discussions, news, articles, and some legal discussions. And we also developed a specialized, what we called hate speech corpus, to try and get away from the legal cases in the general corpus. So we got a corpus of 255 news reports about hate speech related events. They were all UK news reports, even though the things they were reporting might be international. And they ranged from serious press and tabloids, and included both national newspapers and smaller regional ones. And we looked at the period from 1990 to 2021. So those were the 2 bodies that we were looking at. And we assessed frequency, how often hate speech occurred. We looked at the collocations, what expressions hate speech appeared alongside. And we looked at the concordances, we looked at some of the samples. I'm not going to give you the details. Just going to suggest to you some of the things that we thought this corpus analysis could tell us. So the first thing that we found was that there has been a massive growth in the use of the expression hate speech, particularly in the public domain. So in our newspaper corpus, we found that from 1990 to 1995, there were 46 articles that used the expression hate speech. Then in the period 2011 to 2015, there were 2,753 articles, and in the most recent period we had, which was 2016 to 2020, that had shot up to 8,024 articles. So it's an expression that has really taken off in the public domain. It went from almost not appearing at all, 46 mentions, to over 8,000. And we found evidence that the public understanding of the expression hate speech is wider than the legal definition. Because when we looked at the collocations, when we looked at the way the expression was used in the corpus, what we found was that it was very often used to refer to hateful speech that was based on gender characteristics. But that's not part of the legal definition, right? Use of hateful language based on gender characteristics cannot have you prosecuted, as things currently stand, for an instance of hate speech, because it doesn't fall under the characteristics that are protected within the UK Public Order Act. But on the other hand, we also found that the public use of hate speech was narrower than the legal definition, because the legal definition doesn't tell you anything about the kind of power relationships that are in play between the person doing the speaking and the target of the utterance. But we didn't find any accounts of hate speech which characterized speech by a powerless minority against a powerful majority as instances of hate speech, no matter how offensive that speech was, no matter how much you might think it was trying to incite anger towards that target group. So obviously you have to be a little bit careful here, because we all know the scientific maxim that tells you absence of evidence isn't evidence of absence, but still we think this suggests at least that the legal definition is a bit too wide. It doesn't reflect this aspect of the ordinary usage. And finally, we found that the ordinary meaning of hate speech seems to involve more than merely offence. Okay, so when we were thinking about the chilling effect, it seemed worrying, because if hate speech is just understood as offensive speech, there might well be instances that people self-censor where they don't need to. But we found no evidence of that, right? We found that in the public usage, hate speech is reserved for cases which involve incitement to hatred in just the way that the legal definition requires. And what we've suggested in the paper that we've just published on these findings is that those sorts of results may play a kind of ameliorative role. So, for instance, there's a movement at the moment through government to try and revisit the hate speech legislation and to widen the case of the protected characteristics that it applies to. And we think our findings could speak in favour of that, right? Because it may turn out that the public actually already think that's what hate speech involves. So the government will be kind of pushing on an open door if that's the case. Okay, so I'm not going to say any more about this, but I hope that shows you a little bit about why doing an objective study of meaning might be helpful. It might tell us something that we didn't know about the way that these expressions get used in ordinary language. And I've been interested in that, to get way back to the beginning of the talk, because I wanted to know how we're deciding the meaning of an expression so that we can know what the minimal content of an utterance is, so that we know the meanings of the words that we're sticking together to get at this minimal content. So I've suggested that using objective methods can help to shed light on ordinary meaning. And we're probably going to need a mixture of multiple subjective and objective methods to triangulate the content. We're not really going to be able to get just one method that tells us exactly. But now we arrive at the second question I wanted to ask, which is, why bother? You know, I've told you some stuff about how you might try and find out what the meaning of an expression is, but why is that interesting? You know, why do you want to know about this kind of content that tells you just look to the meaning of words and the way that they're stuck together in a sentence? Because think again about the case we started with, right? Little toy case, but I think it's, you know, illustrative of the way ordinary language goes. Someone says to you, do you want a sandwich? And the person replies, I've eaten. You're not really interested in the literal content that this person has eaten at some stage in their history. You know, what you want to know about is, have you eaten recently enough to make wanting a sandwich now unlikely? What you want to know is, do they want a sandwich? Not, you know, some literal kind of content. So why should we bother trying to find out what the standing or the literal meaning of an expression is? Why think it's going to be useful to us? Now, if that's the kind of worry you've been having, well done, because that's the kind of objection that gets made to the position I've tried to defend kind of right since its inception. So let's look at two worries for the position I've tried to defend for minimal semantics. I'm only going to talk about the second one, but I'm giving you both of them just for kind of completeness' sake. So one worry you might have with minimalism, this idea that you get a content just by looking at words and structure, is maybe you don't. Maybe you just look at words and structure, and what that gives you is just a kind of fragment of content, nothing that could really make a claim about the way the world is. So this is a kind of impossibility worry for minimalism. It says that for at least some, and indeed maybe for all, if you listen to maybe the relevance theorists, maybe all well-formed sentences don't deliver us a minimal content without some kind of significant contextual input. An example of that might be the sentence, Jill is ready. You know, does that really make a claim about the way the world is until you've looked to the context to find out what Jill is ready for lunch or ready for the exam or whatever? Okay, but a second kind of objection, and the one that I'm going to focus on here, is this irrelevancy objection. According to this objection, maybe you can get a minimal content, maybe just look at words and structure and you really do get a claim about the way the world is, but it's just not a very interesting one. It's not the one that you need when you're doing communication, when you're thinking about the role that language plays for us. So minimal contents are available, but they're just explanatorily redundant. The only real contents that matter are the contextually enriched ones. Maybe they're the ones that are just enriched a little bit, like I've eaten recently or I've eaten lunch today, or maybe they're the ones that are maximally kind of pragmatically enriched, like I just don't want a sandwich. But whichever one it is, it's a pragmatic content, a content that looks to the context of utterance, not this kind of minimal literal content. So what I want to suggest in the last kind of section of this talk then is that we can get an answer to this irrelevancy worry by thinking a bit harder about the notions of responsibility that are in play when we engage in communication. So my argument is going to be that contrary to this sort of claim, contra to this irrelevancy objection, minimal content has a really important role to play because part of our practice of holding speakers responsible for what they say depends on this very strict, very kind of context-independent notion of content. So what I've tried to argue elsewhere is that when we think about notions of responsibility, when we think about what I like to call linguistic liability, the way in which you might be held liable for the things you say, what we find is that there are actually two very different kinds of practices going on. There's a notion of strict linguistic liability and there's a notion of conversational linguistic liability. So strict linguistic liability, I think, is a binary notion. Okay, it's binary in that you either are or you are not responsible for a given piece of content. And the given piece of content that I think strict liability tracks just is the minimal notion of content that we were looking at a moment ago. And this contrasts with a very different notion of linguistic liability, which I term conversational linguistic liability, which is a matter of degree. Okay, it's not like the binary strict liability, it's a matter of degree. You may be more or less liable. You may be more liable for this bit of content or less liable for that bit of content, but it's a matter of degree. And the contents that conversational liability attached to are the pragmatically enhanced contents, either the minimal or the maximal ones. And I think we can see these two different notions of liability in play when we think about actual practices where we're trying to hold people responsible for their utterances. So here's an example I've used before. Imagine an utterance of the sentence, the train leaves at 11 a.m. And we might be wondering, what the person is responsible for when they say that. Now consider that utterance in two different kinds of context. Let's say I'm planning to meet a friend for coffee in the morning, or she rings up and asks if we can go for coffee. And I say, yeah, well, I'm going to London today, I'm talking at the RIP tonight, so I've got to get going. My train leaves at 11. Okay. When I'm speaking to my friend, it looks as if what I'm responsible for is not the strict literal content of my utterance. It seems that what I say is fine, even if my train leaves at 11:01 or 11:02 or 10:57. What I'm trying to say to my friend is just the train leaves at roughly 11 a.m. The train leaves at a time that's going to make it impossible to have coffee with you. So there are a number of kind of pragmatic contents here, ones that precisify the time in different kinds of ways, and I may be more or less responsible for any one of them, right? I may be more responsible for the claim that the train leaves at 11:01 than I am for the claim that the train leaves at 11:10, say. But it's a matter of degree, and we can debate that amongst ourselves. But now imagine the same utterance when I've rung up the National Rail Office. I don't even know if you can still do this. I imagine actually we all do it on Trainline on our phones, but let's imagine the days where you have to actually ring someone and ask them about your train timetables. I ring up and I ask them when the next train to London is, and the speaker says to me, the next train to London leaves at 11 a.m. great. I run down to the train station, I arrive at 10:58, expecting to hop straight onto my train, and I see it disappearing out of the station as I arrive. Seems in that context, I've got every right to feel aggrieved, right? I've got every right to feel that the National Rail employee didn't give me the information I needed, didn't say the right thing to me, because I can hold her strictly liable for the content that she expressed, right? For the literal content, because of the kind of context we were engaged in, where she was the expert and I was asking her for information, she was required to meet this higher standard of strict linguistic liability. But that standard of strict linguistic liability, I've suggested, just tracks this minimal content, right? It doesn't track the pragmatic content the speaker gets across. It tracks this minimal notion. So just in the last 5 minutes, I thought I might just give you a concrete kind of case which illustrates the practice that we have. Because I've given you a toy example, but you might think, you know, do we really have this practice? Do ordinary speakers really recognize these different kinds of standards? And I think they do, and I think we can see it by looking at another kind of legal example. So this is one of my favorite cases. I think it might be familiar to some of you, which is known as the Twitter joke trial. Do people know this already? Can people remember this? Okay, so it's faded into history, but it was a famous case around the time it took place, which was in 2012. So the full title of this is Chambers versus Director of Public Prosecutions, happened in 2012, and the facts of the case are as follows. So Chambers was at the time a 26-year-old male UK citizen, and he learned that an airport from which he was due to travel was closed due to heavy snowfall. And when he learnt of this, he took to Twitter and he tweeted the following: "Crap, Robin Hood Airport is closed. You've got a week and a bit to get your shit together, otherwise I'm blowing the airport sky high." Okay. So this following, if you don't know the case, should be a lesson to, you know, think carefully before you tweet. So if 5 days later, we might, you know, worry about why it took 5 days for this to come to light at the airport, but 5 days later it came to light at the airport, and it was sent to the duty manager of airport security, who read the tweet and communicated it to the police. So the question we need to ask ourselves is the content he was considering and the content people were considering as the case proceeded. So here is how the case proceeded. We start off with the head of airport security. So what we know is that he sent the tweet on to the police. And that tells us two things about the content he was interested in. Because airport security are governed by really clear protocols that say that if they receive a credible terrorist threat, they need to send it directly to the Ministry of Defence. So if he judged this as a credible terrorist threat, he should have sent it to the Ministry of Defence, which he didn't do. But remember that the words that he uttered were, "I'm blowing the airport sky high." So if he was assessing the literal meaning of that expression, he would have to send it on to the Ministry of Defence, right? Because literally it's a terrorist threat. So what we can see is that the head of airport security must have considered the literal meaning but rejected it as the content that was being expressed. But he didn't just ignore the tweet, right? He didn't just put it in the bin. He did send it on to the police, and that shows that he took it to be a credible menace, right? A credible threat. So he took it to be expressing some content, I guess, along the lines of, if the airport remains closed, I'm going to do something serious. I'm going to turn up and menace the staff. I'm going to threaten them in some way. So he sent it on to the police as possibly having a threatening content. The police took the view that it did express a threatening content, and the public prosecutors decided to pursue the case. So they charged Chambers with sending a message of menacing character contrary to the Communications Act of 2003, and that charge was upheld at the Magistrates' Court. Okay, he was found guilty of that offence. And the judgment there, the only judgment that could underpin that finding, is that he was held strongly conversationally liable for some kind of threatening content. Remember, it's not looking at the literal content, because that would be a terrorist threat and he would have been found guilty of a different kind of offence. But it is finding him strongly conversationally liable. It's saying that, you know, A reasonable hearer would take this as the content that's been expressed, this pragmatic content that I'm going to do something serious to the workers. So what we have is a pragmatic content here being taken as the content he's strongly conversationally reliable for. Chambers appealed to the Crown Court, but at the Crown Court, the magistrate's judgment was upheld. They found that he was responsible for that content. So again, we have a judgment of strong conversational liability for a piece of threatening pragmatic content. Chambers appealed again all the way up to the High Court, and luckily for him, at the High Court level, the charge was overturned. So they found that he was not liable for sending a message of menacing character, so he wasn't held to be strongly conversationally liable for this pragmatic content, although the judges noted that he was weakly conversationally liable. They noted that there was a content that it would not have been unreasonable for someone to have taken, to have felt threatened by the message that Chambers sent, but they said that that didn't reach this level of strong responsibility, wasn't strong enough for him to be found guilty. And again, they didn't overturn his finding of guilt under sending a message of menacing character and replace that with the judgment that he had sent a terrorist threat. So again, they didn't take him to be liable for the minimal content of what he said. So I think this kind of little trip through the British judicial system shows you that actually people do engage day to day with these different kinds of practices. They worry sometimes about the literal minimal content that people express, and they worry on other occasions about the kind of pragmatic content that's being communicated and the degree of liability speakers have for that content. But what that shows us, I think, these kinds of cases alongside much more kind of everyday cases. So if we think about the difference between lying and misleading, that I think a couple of other talks in this series have thought about, looks as if paradigm judgments of lying are going to track this notion of minimal content, whereas notions of misleading are probably more likely to be looking at a conversational pragmatic content. Or if we look at other kinds of distinctions, I'm a particularly big cricket fan. There's a big distinction in cricket between playing with the rules of the game versus playing within the spirit of the game. And it looks like one is a kind of notion of strict liability. The other one is much more concerned with a pragmatic kind of what the rules convey. So if we look at a range of practices that we engage in as ordinary speakers, we're sensitive to this distinction that I've been trying to give you between the minimal content, which says don't look at the context much at all, and the other kinds of content which say let in pragmatic features as much as you need. So we make different kinds of liability judgments, and these are sensitive to different kinds of content. And at least sometimes we do consider assigning and accepting strict linguistic liability, and that just requires a grasp of the minimal content of what a speaker has said. So that was why it was worth doing all that stuff in the first half of the talk, asking how do we decide what the meaning of a word is, because at least sometimes we really need to know what the literal meaning of our words is. So this practice reveals that there is a well-founded explanatory need for minimal content, contra to the irrelevancy objection to minimal semantics. Hooray, I get to win. Excellent. Okay, so let's conclude there. To hold someone responsible for what they say, I've tried to convince you you need to answer these two distinct questions. You need to know, first of all, what is the content that they've expressed? What content are we holding them responsible for? And secondly, we need to know what kind of responsibility are we assigning to them? Just in what way are we taking them to be responsible? I suggested that the most common method for assessing the content of what someone says is just straightforward introspection. We just run with, what we think the meaning is supposed to be. But that in contested cases, that sort of introspection may be inadequate, and we may need to wheel in some more complicated and difficult sorts of objective explorations of meaning. So there is a place for empirical inquiry into ordinary meaning, so something like corpus analysis, something like experiments, though no one method is going to yield a decisive result for us. And recovery of the literal or minimal content really matters, I've tried to suggest to you, because at least some of our practices around assigning and accepting linguistic liability just depend on that minimal kind of content. We sometimes take speakers to have what I've termed strict linguistic liability and contra-irrelevancy. It's that provides this clear explanatory role for minimal content. That's why you need to know what someone is strictly committed to, the literal meaning of their utterance. Okay, I will stop there. Thank you.
Question?
I was thinking about fact-checking, and that, it's clear that some broadcasters are very careful about that fact-checking, and some are not. And then you have kind of internet. Again, it's the same with internet sites. I was thinking you can say kind of broadcasters are more responsible than internet sites are not, but I don't think that's true. I think you get some internet sites who are very responsible about fact-checking, and some broadcasters which are not. So it seems there's a context there as a provider of news that you do have a higher level of linguistic liability than ordinary conversation.
I think that seems right, and actually in a different project that I've been undertaking recently, I've been thinking quite a lot about those kinds of notions, about what it is to be a responsible provider of information. And I think so one of the questions I've been interested in is, how rational should we think of people being when they arrive at what appear to be pretty irrational views? So, what should we say about the climate change deniers? What should we say about people who refuse to wear a mask during the pandemic? One move that's been quite common has been to say that those people are just irrational, that they're forming their beliefs in some way that's not looking at evidence. And I think that's probably too quick, because actually, for the reason you gave, where people are taking their evidence from differs greatly, and the degree of robustness of that evidence may be very questionable in different places. So you may have some website that's providing information, but is actually not doing any kind of fact-checking, is coming from a particular political point of view, and is presenting a very skewed, picture of events. But what I think has changed in recent years is that it's now very hard to spot what status a given information provider has. Are they a good, reliable fact checker, or are they not? Because things look very kind of on all fours on the internet. It's very easy to have a kind of veneer of expertise on the internet. And so what I've tried to argue is that people are much more rational than you might initially have thought. And if they're arriving at these kinds of judgments, a large part of the problem may be the sources that they're looking to for their evidence. Which I'm not sure that's really answered your question. It's a kind of long-winded way of saying that I think you're right. There's definitely different standards of verification of evidence, but actually that practice, I think the practice of taking people to be responsible for what they say in a particular way that relates to a news site, that may be independent of how good a news site they are. So in fact, I think the two may come apart there.
Who's responsible for what ChatGPT says?
Oh, yeah. Okay, good question. So, lovely. We've been thinking about this a lot in academia recently, because people generate their essays using chatbots, and presumably that's not the student who's responsible for it. But I mean, one of the things that I liked about minimalism when I first started pursuing it was that it gave you an answer to why these things are meaningful, right? So if you think of meaning as depending very closely on the particular intentions of the person who's producing that bit of language, it becomes really opaque why AI is very good at producing meaningful strings, right? Because AI doesn't get at intentions, and it doesn't have intentions, at least probably not at the moment anyway. And so what I liked about the minimal approach is that it separates out the role of intention. It says that if you want to know about meaning, you need to look at these kind of notions of standing meaning, where there may be a degree of distance between the thought the person has in the head and the content they're expressing, because the content is fixed by features that aren't just internal to the one-off intention. So I think what I would want to say, so that's an account of how these things get to have meaning when they're produced by AI, because meaning is kind of out there in the world, not just in the head. I guess what I would want to say about responsibility is that, yeah, I guess when the AI first puts a linguistic expression out into the world, it may not be right to ask questions of responsibility. Yeah, I mean, maybe you'd have to say that it's the responsibility of the people that constructed the program, that it's, you know, generating the string in the way that it does.
There's also a concern to do with the person reading it. If you know how it's producing it, you can take advantage of salt. If you say, look, you think at the database, then what you think it's saying is
I think that's right, and I think that speaks to this idea that I do want to stress, which is that notions of liability there's not just one kind of liability that's insensitive to the context. So if we want to know about liability, you know, so that was the kind of example that I had between the saying that the train leaves at 11 amongst friends versus saying that the train leaves at 11 when you're an expert. You know, liability tracks kinds of socio-linguistic features, not just the words themselves. So I guess that would also hold there. But good question, definitely. Yeah.
Thanks. When you say, I think I heard you say meanings in the world with a minimalist or strict interpretation, but is it rather that we mark meaning by having certain canonical interpretations of words and phrases, and we project them onto the world? So you might think it's a nitpicking if it's not. For philosophy, it's a meaningful question, but I don't think such thing as native meaning. It's not that the universe has native meaning. People are religious, and I think it's, but in general. There are states of affairs which we mark and we attribute meaning by saying they are connected thus.
Yeah.
And also we have the intention bit to say.
Yeah, okay, I think that's a good question, absolutely. So you don't really, you know, you don't want to say meanings are just out there in the world waiting for us to find, like we find chairs, and well, maybe chairs are a bit interest relative as well, like we find atoms and whatever. Clearly, the meaning of an expression depends on the existence of creatures like us with a practice of using an expression like this to talk about things like that. You know, that's definitely right. So when I talk about it as having a degree of independence from intention, what I'm wanting to say is that even though we require intentional beings with certain kinds of practices to make that meaning connection in the first place, once you've got that meaning connection up and running, the thoughts that a particular speaker has in their head at the time that they're uttering it, those aren't the thoughts that are going to settle meaning. Okay, it's got to be something more conventional than that.
It has to be attributed to the actual words. We are attributing the semantic content.
Mm-hmm. Yeah, so the words themselves aren't, you know, they're just meaningless marks until we do something with them. So,
well, what I'm saying is you have to conform to certain conventions as to how wide the scope of a word or phrase is. So in that sense, it's negotiation between permissibly interpretable marking, given a probability outcome that it be interpreted in a certain way. So, in a sense, the situation, the context in which a speaker creates an utterance is obviously constrained by what it is in the first place. But so the second constraint is the ability of language to deliver what we want in the way that we want to say it. Is that fair to say something obvious?
Okay, I think I agree, but
So there are a few towards the back of the room. Why don't you go first? And then...
Thank you, great talk, by the way. Really interesting. I kind of wanted to just check my understanding about how you're passing, especially the corpus analysis, because it seems like what that shows me clearly is that there's currently, well, there's been some change in how H speech is used, and you can understand that as then constituting the strict meaning of that word. It seems like what actually is your understanding of the strict meaning of H speech now? Is that one thing, or is that kind of, because it seems like of those parts we have a reason to say it actually has kind of two strict meanings, a legal one and a non-legal one. But does that kind of conflict with the semantic minimalism you're advocating, where the strict meaning really should be the meaning of the words in this, and their arrangement, devoid from the context?
That's a really good question, so thank you very much. And I think, give a typical philosophical answer, I think it's going to depend on quite a lot of factors. Particularly, I think it's going to depend on the way that you were understanding your two meanings. So, minimalism as a theory doesn't have any problem with one kind of surface level expression having more than one meaning. So, we clearly have in our language homonyms, they're fine, bank means both side of a river and financial institution. That's okay. Minimalism can say there's just two genuinely different expressions there with two genuinely different meanings. And I think if it turned out that hate speech had that kind of feature, that would be okay. Maybe there are two meanings. And, to an extent, that's the kind of working assumption we had to have when we were trying to ask whether are they the same. You're having to think that there could be two different meanings here already. For people in the know, something that becomes much more kind of problematic are notions around polysemy. So the idea that one word might have lots of different related kinds of senses all built in. I've tried to argue, I've got a paper that I think is still coming out, has been coming out for quite a long time, on polysemy, so it's quite a big topic that we could definitely say more about. But I tend to think that minimalism could still accommodate those kinds of cases. So even if you thought of hate speech as a kind of polysemous type expression, which had slightly different senses in the legal case and the public sense, I still think that's something that minimalism could accommodate, but it's going to be slightly trickier. So again, I'm not sure I'm really answering your question, but I think what I'm trying to say is that it will depend on what your account of two meanings is, whether minimalism is going to be totally happy with it or not.
You're not tempted to say something like, what the strict meaning of hate speech is going to depend on the context in which that person means, whether it's a blog or whether it's a written paper.
Okay, so that's a really nice question, and it pushes on the distinction between, kind of a minimalist approach versus maybe a relevance theory approach or a contextualist theory approach, because what they're going to want to say is that you fix the meaning of these expressions much more kind of on the hoof than a minimalist seems to think. You engage in a big degree of negotiation every time you debate with other people, and that's what's fixing the meaning. So I think you're right that if that's not what I'm tempted to say. No, I would like to retain more of a degree of context independence for these contents. But you're quite right that it's going to get us into some pretty tricky arguments. Thanks.
Yeah, in the back.
Do you think we can hold people successfully linguistically liable across languages without being fluent or at least having a sort of colloquial sense of the language?
Okay, that's a really nice question. It's not one I've thought about, so I should definitely think more about that. My sense is that, maybe if you were really not fluent in another language, your judgments of liability are likely to be compromised in those kinds of cases. And that's particularly because, getting at what someone has actually communicated by the saying, getting that notion of conversational liability really is sensitive to the kind of local conditions. And if you're blind to the local conditions, you may, miss out on those kinds of contents. What I do think is interesting, though, is that blindness to local concerns is not a complete defense against claims of liability, right? So if you use an offensive term and you say, oh, I didn't know that was the history of the expression, I didn't realize it was offensive, that's your problem. That doesn't seem like a good response, right? It looks as if liability still sticks with you in those kinds of cases. So I think it's going to be, and I think this is just something I should think more about, how you walk that kind of balance between being sensitive, thinking that liability is sensitive to knowing about local conditions and local circumstances, versus recognizing that as a speaker or a hearer, you don't have the final arbitration on liability, Yeah.
So just as you were saying about the the monster example, surely the reason why they can wiggle out of it is because they're threatening. and that's the whole context, is that they can do whatever they like because there's a credible chance that they will come and, you know, shoot the place up. So that I just was it that you're talking about the assignment of responsibility and all that. So if the assignment of responsibility is reliant on the context, then deciding whether to ignore the context is reliant on already having thought about the context. And so doesn't that always have to come first? And so in some contexts it's appropriate to go to a minimal approach. You've already done the contextualization.
Okay, good. Okay, good. So it's quite right that to decide what kind of liability is in play, you're going to need to look to the context. The difference is that if you're a minimalist, what you think is that the content in question can be settled without looking at the context. So the question of liability, okay, so take the mobster case, right? So the mobster says, you know, nice restaurant, let's hope nothing happens to it. Where the context comes in for the minimalist is asking, you know, the context comes in asking what notion of liability is in play there. Should we hold them strictly liable for the claim, that's a nice restaurant and I hope nothing happens to it? Or should we hold them strongly conversationally liable for a different kind of claim, like I'm threatening that if you don't pay me the money, I'm going to burn the restaurant down? So you're right, context has to come in, but it doesn't come in to fix the minimal content, right? The minimal content is just fixed by the words and the way they're put together. What matters from the contextual point of view is whether that's the content we're interested in. Does that help at all?
I guess I'd probably fall into both of the two categories of relevant possibility and the other one as well that you put up. So I just it just seems so nested in context. So of course there is a context in which approaching something as a binary is totally appropriate because there are binary things and they let us build computers. But to kind of know to use that because you're in a legal context or because you're in a context of trying to decide whether you should pay them the money or not, because that will have a meaningful outcome. I think it's just so nested.
Yeah, I think that's right, but I think I don't want to disagree with you, right? Because absolutely that's going to depend on the context. But ask yourself so go back to the first question we asked, which is what is the content that's expressed? So, you know, when Bishma says, I've eaten, what content gets expressed there?
Can I ask you to elaborate on expression then, and possibly in contrast to impression, if that's not too many?
Okay.
What do we mean by an expression? What are we trying to...
Well, say assertion then, maybe. Is that better? All I'm trying to press you on, I think, is just, it's absolutely right that you can't settle these questions without looking at the context. As a minimalist, you're not trying to say, don't look at the context, only ever look at the words and the way they're put together, because, you know, so as I said at the start of the first book, you know, why am I calling this minimal? It's minimal in lots of sense, but one of the really important senses in which why I think my theory is a minimal theory is that it's playing a minimal kind of explanatory role, right? I've tried to argue that it's really important, but I'm definitely not saying that it explains communicative practices in general. Communicative practices in general really depend on the fact that we are amazing creatures who can track, in ways that are very difficult to see how we do it, the contents that people are trying to get across, where those contents really very often don't look very much like the literal meaning of the sentences they produce at all. You know, 100 times a day before you have breakfast, you've got at the message that someone's trying to convey to you. When that message was not fully encoded and may not have been encoded at all in the contents that they literally expressed. So I'm definitely not trying to tell you that context doesn't matter. You know, context is absolutely, for communication, you know, a really huge part of the story. All I've been trying to suggest to you here is that What you need to do when you're thinking about the content someone has conveyed in context is sometimes be sensitive to the strict literal meaning that they produced, because there are some times where that's the content that you are interested in. And you're right that deciding whether it's a context in which that's the content I'm interested in is itself a context-dependent matter, but that still doesn't play back into the context because, back into the content, because if you think about the toy example we began with, what I was trying to suggest to you is that there just is a content, namely the content that Bishma has eaten, which is just given to you by looking at the meaning of the words and the structure of the sentence, and doesn't ask all of these additional kind of contextual questions. So I don't know if I've convinced you, but that's what I'm trying to say, I think. Thanks. Good question, though. Thank you.
Thanks. I mean, I guess maybe this is kind of related to this question. So, the notion of liability targeting the minimal content, like tracking that, like strict liability. Like in the case that you gave, like I'm going to blow that airport sky high,
Yeah.
or the nice restaurant would be ashamed if something happened to it. So it's like, the minimal content of those things is that proposition that's expressed. And then it seems like the thing that we would want to hold people liable for is like a speech act that's performed, like a threat, or in both cases the threat, right, as opposed to a mere observation, in the case of, oh, it's a nice restaurant, something happened to it, or a prediction, or, a promise, or something like that. And so, but the speech act content isn't part of the, what speech act is being performed isn't part of the minimal content. How would you use the minimal content to do this responsibility kind of thing when it's, it seems like you could do it if what we were doing was like holding somebody responsible for just describing, kind of like, yeah, did you say something true? But then it's like all the really rich legal stuff is like, did you issue a threat? Was it a credible threat? And it's like, is that like, can that be part of the minimal content?
Okay, so I think 2 points there. I think firstly, I would probably not fully agree with the claim that all the interesting stuff is about the Speech Act. So, the cases I gave you about widow versus wife or husband, those are just, cases about where we're drawing the boundaries. And if you think of the kind of classic cases in philosophy of law, is it a vehicle in the park when an ambulance drives in? If you're not allowed vehicles in the park, can you have an ambulance? Those kind of classic cases, those aren't about the Speech Act. They are just about the content. So, so I get those cases, that's good. But then you're right, there are a whole bunch of cases where what's going to be interesting is the Speech Act. But it's not the Speech Act on its own, right? Because it is the Speech Act plus the kind of content. To go back to the case, the Twitter joke case, it's a Speech Act of threat, but what kind of threat is it? If it's a threat concerning the literal content, then it should have gone to the MOD as a terrorist threat. If it's a threat with some pragmatic content about, I'm just going to do something pretty bad here, then it's got to go to the police. So the Speech Act, the kind of Speech Act you're engaged in, isn't part of the minimal content, but it's still going to require a sensitivity, I would suggest. I would hypothesize.
Do you want to come back?
Not really deep, just about the history of development of semantics. Are you in the tradition of Charles Morris? I don't know if he's the first one to distinguish between syntax, semantics and pragmatics. I don't know if that was his. I forgot the history of Physicists have been working in that domain way back when pragmatics, legality, semantics. Sorry.
That's certainly right. He's a big figure in there. For the distinction between kind of signs and signifiers, and when you're thinking about the relationship between the items in the language, the things in the world they're trying to talk about, and then the context.
Various contexts, graphic semantics onto actual state of affairs, give the possibility of multiple interpretation of the context not the same level. It's a preferred interpretation.
Yeah, and that goes a little bit back to the question earlier where we were thinking about the notion of polysemy. So, that's one thing you might think, that's one kind of model you might have for understanding polysemous expressions. So, something like lamb meaning either the little jumping around furry creature, woolly creature, or the thing on the plate that you're about to tuck into. Maybe context needs to determine which of those two polysemous senses is in play.
Well, just on building on the speech acts, I've been thinking about intent and whether that widow and widow one, you've argued it's just a concept and the meaning of words, but is the reason it's the core, is it because they were trying to argue about the intent of the person writing the law, and maybe that intent is support for someone who is financially dependent on someone who died, when historically the wife wouldn't have had a job and therefore that's why it's something like that. And so the intent is to support the spouse.
So that's that is a really big question, and what you're tracking there is some very live debates in philosophy of law and the philosophy of language, of legal language. So, there are different positions on what it is that determines the meaning of a given statute or a given piece of legislation. Some people say what you're trying to get at is the intention of the lawmaker. So what wrong were they trying to intend to prohibit here? Some people say that what you need to think about is not kind of the intention they had, but what was the purpose? What role is this piece of legislation trying to play? Some people, the so-called textualists, particularly in the States, say that you shouldn't ask about the intentions at all, because that, you can't find out what intentions they had. What you need to focus on is, what did they write? Look at the words and see what the content is. So, the people who really think that the American Constitution can't be, messed about with in any kind of way are these sort of originalists who think you've just got to look at the words and the, focus on the script. So I think to answer your question, we'd probably need to decide what we think of as the right way to interpret a given piece of legislation here. I think what's interesting with the widow case is, they didn't really, I think reading the case, it doesn't look as if they were so concerned about what the purpose of the piece of legislation was or what the intention of the lawmakers were, because they thought they had enough kind of textual evidence to give them the reading that they wanted. So I think that was what Hoffman was alluding to when he said, in other places, the draftsman used clearly gender-neutral language, where they wanted a benefit to apply to both, they explicitly stated it. And because you haven't got those kinds of things, you haven't got evidence that this expression should be given a wider usage. But I think you're right, that once you start thinking about these kinds of things, you get into these questions of interpretation, and clearly different theories of legal interpretation are possible. So,
Well, that brings us to time. Emma, thank you so much.
Thank you.